for the operation of the storage facility and regasification and operation of the FSRU, operation of the storage facility and as well as regasification, the transmission, the distribution operation of the in order to be able to transport the gas that it intends to use for generating power, as well as to trade in gas to be able to in various areas of South Africa. So those are the various license applications that are before us for the regulator to consider. My name is Nomfundo Maseti, and I'll be presiding over this hearing today, and I'm assisted by my colleagues, and I would like my colleagues to introduce themselves. Let me just activate the video, and I would like my colleagues to also introduce themselves, or I can introduce them. If you can kindly activate your camera when I introduce you. I'll start off with Mr. Nhlanhla Gumede, who is the full-time regulator member responsible for regulation of electricity at NERSA, and is also the member of the Piped Gas Subcommittee. Welcome, Mr. Gumede, and good morning. Thank you very much. And I will also go to Mr. Musuvukile Mkhize, who is the full-time regulator member responsible for the regulation of petroleum pipelines at NERSA, and he is also the member of the Piped Gas Subcommittee. Good morning to you, Mr. Mkhize. Thank you. Good morning. Good morning. Thank you. And lastly, I would like to introduce to you Advocate Nomalanga Sithole, who is also the full-time regulator member at NERSA, and is also the CEO of NERSA and the member of the Piped Gas Subcommittee. Good morning, Ms. Sithole, and thank you very much. Before we proceed, I would like Mr. Walter Mabunda to assist us just with the ethics moment before we kickstart the hearings today. If you could kindly remind us about our ethics moment before we start the business of the day at NERSA. And if possible, you can also touch on the message regarding safety very briefly. Thank you.
Occupational health and safety management for NERSA is not just a compliance requirement, but has become a culture of how the organization functions on a daily basis. Top management has taken both the responsibility and accountability to assure the health and safety of all stakeholders accessing NERSA's premises. When working away from the office or from home, it is important to ensure that the working environment is safe and secure, and that the virtual private network or VPN is turned on, so NERSA's systems are not compromised. When in the office, everyone must adhere to the health and safety guidelines and familiarize themselves with the marked NERSA evacuation routes. In the unforeseen event that may arise, you will be required to evacuate the building following the orders of the evacuation marshals. The evacuation procedure is as follows. When the alarm goes off, everyone must leave the building immediately. In the event of a fire, the following steps should be taken to ensure the safety of all building occupants. The appointed health and safety representatives, floor marshals, fire marshals and first aiders will be responsible for the orderly evacuation of their particular floors. Occupants of the building must follow the instructions of the health and safety representatives, floor marshals, fire marshals and first aiders, and must comply with all instructions given verbally through megaphones. Never ignore the instructions of the health and safety representatives, floor marshals, fire marshals, and first aiders. Do not select your own escape route. This must only be done in the event that, for whatever reason, the emergency response team is unable to perform its functions. For example, hostage situations and major bomb explosions. If you are in your working area, take only personal belongings. Do not attempt to take more than you can carry. If you are not in your working area, do not go back to collect items. Stay calm, walk briskly, and do not run. Walk in single file and keep to the left-hand side. assist injured persons or persons who stumble. Remember, in a chemical or biological incident, assistance is not advised unless you have protective clothing. Do not shout or make unnecessary noises. Do not interfere with persons performing emergency services. Proceed straight to the prescribed assembly point and report any missing persons to the authorities or health and safety representatives. Do not return to the building until authorized to do so by the emergency controller. Stay calm and do not panic.
Thank you for the safety video. I would like to then proceed to the start of the hearing. Members, as indicated, I will be chairing today's proceedings, and I will be assisted by my colleagues who have already introduced themselves. And it is important for me to inform you that this hearing was duly advertised in the various newspapers, including Business Day, Afrikaans Central, Daily Dispatch, Cape Town's, the Mercury, the Beyond, and on the NERSA website. And the hearing itself, and it is governed by the National Energy Regulator Act of 2004, in which affected parties are given an opportunity to submit their views as well as to present relevant facts and evidence to the energy regulator. This is so that such evidence and facts could assist the regulator in coming to an informed decision. And this hearing as well, it is indicated by NERSA's rules on public hearings. And I'm summarizing some of the key points from those rules. All the parties will be required to make their presentations under oath, and those are the parties that have requested to make presentations today. So they will be doing so under oath, and the presenters have been allocated 20 minutes each, and 35 minutes have been provided to the applicant. In this case, it will be Karpowership that will be given that 35 minutes so that everybody can have a clear understanding of what is involved in Karpowership applications that are currently before us. And please note that we had a previous hearing that was held in March, and this is the second round of the hearings that we are having, and it was important that we should also include the applicant to be able to, again, summarize the key and salient features of its application, and also be able to come in the end to provide final remarks on its applications, and also try in its final remarks to provide some responses to the issues that may have been raised by various stakeholders during their presentation. So that will be the role of the applicant in today's public hearing. Only the members of the panel may ask questions to the presenters. However, if there is a member of the public that wishes to get clarification or provide ask NERSA to ask certain questions to the presenters, please send an email to walter.mabunda@nersa.org.za with the questions that you would like the panel to ask, and then the panel will look into the question and decide how to deal with the question and how to pose such a question. Should presenters wish to present information that they consider confidential, please let us know about that information so that we can make a ruling on whether or not we need to close the hearing, so that from the other attendees, so that we can only have the employees of NERSA as well as the panel to hear such confidential information. The record of this hearing, which is recorded by the microphones, will be the official record of this meeting. In terms of the House rules, I would like to request that all the attendees today, you must mute yourself and do not put questions or raise your hand for us to ask you to present your views, because you will not be given that opportunity. As indicated, you can put your question for the members if you are not presenting, to ask that question from the presenters. And please keep your cell phones on silent, and please keep yourself muted. Do not switch on your cameras, and would like to really implore on you to observe these rules so that you do not interrupt the proceedings and delay the hearing itself. Today we received only 5 requests for presentation, and now we will start with a Karpowership. I have the name of Mr. Mehmet Katmer from Karpowership. I would like to then ask Mr. Katmer to activate his camera. Thank you very much. Do you have any objection to taking an oath?
No, I don't.
Thank you very much. May you please raise your right hand? Do you solemnly declare that the evidence you're going to provide before this panel today is the truth and the whole truth?
I do.
Please state your full name and your portfolio at Karpowership for the record.
My name is Mehmet Katmer, and I'm a director in Karpowership, South Africa.
All right, thank you very much. You may start with your presentation. We are assigning 35 minutes in total for your presentation. Thank you.
Thank you very much. If you could, someone give me the access to present for the timing. I'm just an attendee.
All right, Gerald, may you please assist?
Okay, now I can. I hope everyone can see the presentation.
Yes, we can see it. Thank you.
Thank you. Okay, let me start. Good day to the panel chairperson, members of NERSA panel, sector stakeholders, and valued members of the public. Thank you very much again for having us here to explain our project and our gas license application. We sincerely appreciate the opportunity. As this is an additional public hearing, and we have presented the project recently 4 weeks ago, today I'll not be repeating the basics of the project or the technology, but mostly covering the areas which were addressed to us during the last public hearing and following questions by the stakeholders, various stakeholders. We acknowledge that there might be further questions related to the project and the applications, and we will be very happy to address those as well. So today we hope that we will be engaged more deeply into the project and explain the merits in a more transparent and constructive way. So without further ado, let me start. Just to capture the scope why we are here today. We are here today to discuss our gas license applications for all our 3 projects, Kuha, Saldanha, and Richards Bay. This is a generic layout just to demonstrate the licenses that are in now we are discussing. One is the application for a license to operate a gas storage facility, which is the FSRU. The second license that we applied is the operator regasification, gas regasification facility. It is again in our floating storage and regasification unit. The third license that we applied for is to build a gas pipeline between the FSRU and the power ship. And the fourth license is for the operation of such gas pipeline. As I said, given the time restraints and we would like to have more questions, we will not go into too much detail of the previous public hearing, but if there are technical questions, I am also happy to point out the people in our team to address those. I'll not repeat the history of the company again, but as you could see, we have a global portfolio in excess of 5,000 megawatts. Hopefully, once we deliver the projects in South Africa will be our biggest project in terms of installed capacity. But as you can see, it is not our only project. We have other LNG to power projects all around the world, from Asia to Africa and to Americas. And we are going, and we have gone through similar permitting processes. In today's world, developed or developing countries needs power or gas infrastructure fast. Reasons might be different. Sometimes it's lack of power. Sometimes it is security of supply and diversification, as this is the case in Europe, as we all know, as we speak now. So here the summary is, we have delivered these kind of projects, and we are currently operating in 17 countries around the world. Some words about our entity in South Africa, Karpowership South Africa. Karpowership South Africa is 49% black-owned and women-empowered BBBE entity. Important points that I want to underline here are, one, although some critics might not agree, we believe that first, South Africa needs power now. And second, and more importantly, gas is the transition fuel on the path to net zero emissions. If you want to have a power mix, it will be majority renewables, and we fully support that. And we are, by the way, as Karpowership South Africa, following renewable opportunities in that space as well. And we have renewable power plants around the globe. Then you would definitely need flexible generating assets, mainly thermal assets. If you look to what's happening in the last couple of months in Europe, even Germany, which I think is the country that has the biggest renewable share in Europe, they are investing into fast-track LNG import terminals as of now. And luckily, Integrated Resource Plan have already set the direction in all of these items. And we believe there will be additional demand for gas, not only for power, but also for industrial applications. So one topic is, we believe the transitionary fuel should be gas. Second, about Karpowership South Africa, what we are doing while we are working day and night to get the authorizations from different authorities, we are engaging with our local communities. Our community liaison officers on 3 sites are daily contact with the people and the organization in our sites, explaining them where we are in the process, what are their needs, and how we can create a working relationship during the project execution and the operational period. We feel their support every day. Despite how it might look like in the media, we are very happy and proud that we are at least able to communicate the benefits of the project to our local communities. And one of the most important criteria for the award of the RMIPP was economic development. And we believe with LNG and gas infrastructure, the economy that those jobs, the jobs that will be created by that economy in those 3 ports will be much bigger than the direct employment opportunities combined in the entire program. So we believe there's a significant opportunity here for the country, and that's what we continuously engage with our stakeholders. From here onwards, I will try to address the issues that have been raised during the last public hearing and the questions from various stakeholders. First, the solution itself. Now, I will try to cover 3 topics here. One is the flexibility of the solution. Second is the sustainability, affordability of the solution. And third is the term, which was a topic that had been widely discussed during the power generation license applications, first public hearing of gas license applications. And I believe this might be raised here as well. So on the I would say misinformation that some parties use is the contents of the word urgent and emergency. Yes, the RMI4P came out as a urgent risk mitigation procurement because the power is needed urgently, and the level of load shedding, we believe this is an important project for South Africa. So the reason why a 20-year term has been selected, for any dispatchable, reliable and efficient power, longer term means more competitive prices. And to be honest, from a floating power plant, from a floating mobile asset point of view, contract term was not the biggest issue for us. I think the term is introduced long enough to attract other solutions, hybrid solutions, to increase the competitiveness of the program, which in my view, it was a successful attempt. And among the bidders, among the winners now, there are both renewable and hybrid technologies, as well as LNG projects. So the term brought the cost down for the project, which is originally planned to be delivered in 12 months. But again, one important point that I would like to underline is 20 years might not necessarily mean committing to our LNG solution for 20 years. In the implementation agreement that we will hopefully enter, government has the flexibility to take out LNG supply or FSRU part as well. Secondly, LNG, and especially floating LNG solutions, are the most flexible solutions, very different than on-land gas pipelines or on-land terminals, when there are much more construction-related disturbance during the execution of the project. And when renewable energy projects are sufficient to service the base load, and when sun is shining and wind is blowing, you can always reconsider the sizing of LNG infrastructure. You can downsize. And when renewable is not there, as we see big hydro reservoir problems around the world, then you could again reconsider your decisions. So I think our solutions today are even more relevant compared to 1 year ago for South Africa. And regardless of long-term decarbonization and net zero emission targets, countries need security of supply and flexible LNG to power solutions. And the last point is about the affordability, which was again discussed and raised. There were questions regarding the current high spot gas prices around the world. Yes, mainly due to COVID and then Ukraine-Russia conflict, gas prices increased globally. But it's not only gas. It's diesel, it's coal, it's oil prices that have increased. And not only oil and fossil-related fuels. Price of copper, price of steel increased. We have entered into an inflationary area all around the world. And now the cost of renewable energy has also increased. But if you go back to our LNG prices, if you look at not only current spot prices, but more to the time that we are planning to deliver these projects, some years ahead now, you would notice all reputable institutions forecast the current price levels are not sustainable and prices will go down and normalize. So analyzing our projects under the lens of current high and not sustainable gas prices, we believe will not give you the right answer. And again, as I want to repeat, when government finds a better LNG deal than our offering, they always have the right to switch to those solutions and cancel ours. So in summary, we believe there is enough flexibility in terms of the term of gas side in the agreement. And our solution is a flexible and a good start to introduce LNG into these ports, and not necessarily a permanent solution which can serve all the demand, and it's sustainable and affordable. Second issue that I want to address is the concern around third-party access. And we understand there is a necessity around third-party access, and in other words, the concern around sterilization of ports. First of all, let me start with our design philosophy. As a part of RMI 4P programs RFP, which was issued August 2020, bidders were given several options for their fuel choice if they want to use fuel. And the options were diesel, HFO, pipeline gas, and LNG, if I'm not mistaken. As the most competitive, flexible, and importantly, environmentally friendly solution, we picked LNG. However, as we all know, currently South Africa does not have an LNG import terminal. So to be able to implement our LNG to power project, we added the FSRU component into our solution, which you could see in these layouts. These are the three layouts of our three projects. The general design philosophy of our FSRUs are a bit different than the FSRUs in the market. Generally, the FSRUs, the conventional FSRUs that are in the market, they are designed to feed national gas grids. Hence, they have bigger storage, larger regasification capacity most of the times, and higher pressure send out. But the difficulty with those FSRUs, they are not generally cost competitive for this size of LNG to power projects. 4 years ago, under our joint venture with our Japanese partner, Mitsui Osaka Lines, MOL, we developed a tailor-made FSRU solution to be cost competitive and to be able to deliver very fast into these markets. The main difference of our FSRUs, they have relatively smaller storage capacity, enough regasification capacity for our Karpowership projects, and a certain increase, and low pressure send out. Now, when we think about the third-party demand, third-party access, we can comfortably say that our design allows us to increase the regas capacity on the FSRUs, we think, which creates an opportunity for further gas supply for other projects. And that I also want to touch upon. In order to get the best LNG price during the bid preparation time, we ran a very competitive, very comprehensive LNG supply tender, where we invited all the big players, from oil majors to LNG traders to national oil companies around the world. And as a result of this tender, we have agreed with our LNG supplier, Shell, to be our exclusive supplier for our projects in the RMI 4P program. And here, as Karpowership and on behalf of Shell, we understand that there might be additional demand coming from third parties in these ports. These demand can be LNG storage, regasification, or natural gas supply. We have communicated this to NERSA on a written basis that we are ready to explore such opportunities and give access to other users. But the important thing that we need to think about, under our power purchase agreement with Eskom, we have certain commitments, performance guarantees, a dispatchability guarantee, and availability guarantee that we always need to prioritize. And on the commercial side of the third-party access, as we all know, NERSA has already guidelines and rules set in place, which all players, including us, will have to follow, both for LNG price, maximum gas price calculations, storage, regasification, service charges. And if there is further demand for the molecule or the service, we are ready to consider to bring a higher spec FSRU to these ports. So our openness for collaboration, I think I try to make it clear that we are open to explore those. In the implementation agreement, I'm repeating this again to make it very clear, DMRE will have the option to switch out our fuel supply component with a permanent solution, where they can either take out LNG supply or FSRU or both. So actually, we shall consider our FSRU solutions as easily replaceable. So in summary, we believe there is no such thing as sterilization of these ports by our solution. On the contrary, we think testing LNG demand with our cost competitive solution and an anchor power demand from our power ships, they are linked, are the best way to decide any future permanent plan for South African energy mix. So the last part that I would like to touch upon is where we are in terms of our key authorizations. I covered the two of them which have been addressed to us in several occasions, which I think are the two key authorizations that we are waiting to be granted to reach financial close. So we think it is prudent to update the public on the processes. First, the environmental application. After completing the environmental application process, which I mean putting together a extremely comprehensive environmental impact assessment in full compliance with the applicable law, we submitted these final environmental impact assessment reports to DFFE last year, April. Actually, it was 26th of April last year for 3 projects, Kuha, Richards Bay, and Saldanha. The DFFE refused our environmental authorizations in June last year, and we appealed these decisions in July 2021, 13 July 2021, as per the regulations under the National Environmental Management Act, NEMA. As Karpowership South Africa, we firmly believe, and based on the advices of environmental specialists and expert studies conducted during our environmental impact assessment, that there are no environmental fatal flaws in our projects. And our projects have solid environmental merits and excellent socioeconomic impacts, alongside being a speedy solution to elevate load shedding. So we strongly believe that appeal grounds are incontrovertible and the appeal should be upheld. But when we go to the timelines, why it took so long? According to the timelines stipulated in NEMA, the DFFE should have made a final decision in 90 to 120 days from July, the date of our appeal. But as of today, 29th of April, more than 10 months, we are still waiting a final decision. Obviously, we very much welcome the approach of appointing an independent expert to have a recommendation. That's what we are waiting on the environmental authorization. Second, maybe it's more linked on these gas licenses, is our engagement with Tmpa and the Section 79 Directive. Some background: as a part of RMI4P and to accommodate our technical solution, we are required to secure port access after the award and land rights from the Tmpa for each project as per National Ports Act. So we made our application for a ministerial directive under Section 79 of the NPA on 12 May 2021, almost a year ago. So to our knowledge, this application needs the Ministry of Transport's continued consultation with Ministry of Public Enterprise in accordance with the consultation process of the NPA, which takes time and is definitely outside of the control of us. But from our continued engagement with the SIP 20 committee of the presidency, we know that the application for Section 79 directive is currently with the Ministry of Public Enterprise as the shareholding minister, and hopefully was come before the Presidential Infrastructure Coordinating Commission within days. However, due to the unforeseen and devastating flood in KwaZulu-Natal, this was postponed, but still, we believe that Section 79 directive would be issued shortly, not only for our project, but other projects in the RMIPP as well. But while we are waiting for Section 79 directive, we had continuous engagements with Tmpa, and we currently have 3 ongoing work streams: technical, legal, and commercial. On the technical side, there has been an immense study. We have completed detailed designs for vessel locations, have made full bridge simulations, finalized HAZIT and HAZOP studies. On the legal side, we are negotiating a port access agreement, and there has been several commenting sessions. And on the commercial side, we have also, Tmpa also recently communicated the charges attached to the projects within these relevant ports for the service and the port.
Minutes left. You have 4 minutes to wrap up the presentation. Thank you.
Sure. So to sum up, although the process is progressing slowly in the absence of a Section 79 directive, there is no negative indication in our engagement with Tmpa. We are in continuous contact and discussions. We believe the Section 79 directive will be issued shortly, and we will be passing this important milestone as well. So, as one could see from this Section 79 directive, Tmpa engagements, or the DFFE process, the reason of our projects of RMI 4PP is delayed is not because of mainly our thing, but the process taking a little bit more time. Without these delays, actually, the processes would have run as scheduled, then our power ships would have already been on track to connect to the country's grid this August. We definitely welcome the environmental organizations, NGOs, and their scrutiny around our project. And this is not unique for South Africa. This is a global trend. We definitely should protect our environment. And you could see from our extensive EIA application that we are fully committed to this goal. But what is different, in my opinion, there is a concentrated effort to slow these, especially our project, which is actually not the only project in our MIPP program. Our approach is, these processes are, these unreasonable and unfair attacks are slowing the process, which we think South Africa needs all of these projects from our MIPP program very quickly, and we definitely remain fully committed to deliver all of these projects. So that brings the end of the formal presentation. I hope the evidence that we show in the presentation would be enough for the public to understand the projects. And we really appreciate the opportunity afforded to us today. And we stand ready and willing to answer all the questions regarding our gas license applications. Thank you very much.
Thank you so much, Mr. Katma, for your presentation and for your clarification and emphasis on certain areas for the benefit of the public, and also for NERSA to better understand the proposed operations. I will kindly request you to have a piece of paper and a pen in case there will be questions coming from the members of the panel. I'd like to allow the members of the panel to ask questions given the presentation from Mr. Katma, and any other question that is contained in the applications that are before us. A show of hands, members, if you have any questions to ask at this stage. I'll start off with Mr. Gumede. You may go ahead, sir.
Thank you, Chairperson. Good morning to our valued stakeholders, members of the panel, as well as the members of the public that are attending this public hearing. Chairperson, I have three questions for Mr. Katma. The first question is, does Powership actually need gas supply for its power generation, or do you need to own the actual gas that goes into your? Well, I guess I'm hoping that I'm clear here. That says, in terms of power generation, there's the power side of the business, then there's the feedstock. Do you need to also own the feedstock? So that's the first question. The second question, which is going to be a question I'm going to ask all participants today, because it seems to be a theme that we need to address, maybe just for the benefit of the public, so we get a better understanding. Mr. Katma, do you know of any economy in the world, other than perhaps Norway, that do not have gas in their energy mix, especially for power generation? I guess when I'm saying gas, in some cases it could well be diesel or jet fuel. But do you know of any economy in terms of the statistics, and if you can perhaps assist us, if you have any statistics that could help us make the decision and maybe communicate the correct message to the public. Is there any economy in the world that does not have gas in its, especially a developed economy, that does not have gas in its mix? The third question, Mr. Ketma, is in terms of your offer, looking at the PPA terms that you may want in the terms that you may want to conclude with, say, the utility that will buy the power, your power. Is your PPA or your offer split into two, or is it a single offer? That is it split into capacity, that is availability? Do you have a part on availability? And secondly, split into a second component, which could be an energy charge, that is one that is linked to the cost of gas and when we are actually called on to deploy. Those are my questions, sir.
Thank you very much, Mr. Kumete. Mr. Mkhize.
Thank you very much, Chairperson, and thanks, Mr. Katma, for the presentation. I would just like to I've got about 4 questions. One is the issue of the financial close and the timing of the project, just to give us an idea as to where are we and sort of the timelines associated with that. And with that comes the issue of these other authorizations that you have mentioned. And you have said that the process is being slowed. But I just want to confirm here that there is nothing really from your side that is still outstanding in this regard. Because we as a regulator, an economic regulator from our side, we ceased with what the policy and the law requires of us to do. We don't seek to be a super regulator stamping on other regulators' toes. But however, whenever we regulate, it's also important to make sure that whatever license is issued, it then finds expression in the actual operation and the execution of that license. Hence, the need to understand really what are the other issues that are holding things back. And if you can just confirm to me that the Section 79 has not been declined, but has been delayed. Just want to make sure that I understood you correctly in that regard. And then, excuse me, when it comes to the exclusivity of your contractor, you say that you are going to look at it later, but you are committed. Is it not possible for you to look at it upfront in terms of revisiting the contract such that it does allow third-party access without any problem? So it's the issue of third-party access that I would just like to get some clarification on. And then the other issue I have is because you are giving a vertically integrated solution, and I'm looking at it. I'm saying to myself, with the history of the country, which I think you are well versed with by now, is the issue of maybe allowing other players to get into the segments. What is your view around that? In not just empowering by way of provision of service, but by also the segments. Have you looked at that, and what is your view in that regard? I think I've exhausted my questions. Just to assist me in terms of this. And the other issue, oh, by the way, the last issue was around the 20-year period in terms of it being aligned with the authorizations and the licensing. Just like to get your comment there, because I think it's part of what we had asked in the previous round of hearing. Yeah, that's all from my side. Thank you.
Thank you, Mr. Mkhize. Mr. Tole?
Thank you, Chairperson, and thank you, Mr. Kadna. I just have one question which relates to issues of safety. You have indicated that you are currently operating in 17 countries, and I just wanted to find out if you have had any issues or challenges with regard to the safety of your power ships. Thank you.
Thank you, Ms. Sutolo. Thank you. Thank you so much. Mr. Katma, some of these questions that we're asking, you have provided some responses in the previous hearing. We have also, some of the responses were not adequate. We had given you an opportunity to provide written responses within 7 days. We have received some responses, but we haven't received others, including the status of the 20-year contract with the customer, in this case, which is Eskom. So we asked about the status of that contract and whether it has been signed and where are we with regards to that. So part of that, we did not receive the information in relation to that. And also the information pertaining to the required environmental impact assessment. There are questions that were asked that we still have not received. I just wanted to put that on record as the applicant, to the extent that the regulator has not received the information that it expects from the applicant in terms of cooperation and in terms of ensuring that the application will be processed in a seamless and be expedited and be processed in an efficient manner. So I wanted to just indicate that this is what we received from the team that is working on this application. So it is something that I thought I need to raise. Now, coming to the questions, and these questions really relate to concerns that we are still grappling with. Hence, we have not rushed the decision. We thought that we need another round of public hearings. And these questions, they need to be dealt with carefully. The first issue that we are still grappling with, and sometimes it's an issue of interpretation, and also to be able to clearly understand the scope of our mandate in terms of the law when it comes to infrastructure that is licensed by NERSA, where that infrastructure is going to be operated in the ports, and another regulator is required to grant permit for the operation of the infrastructure in the ports. So you do then get some complementary jurisdiction in that respect. Now, there is an issue of the sequencing of the regulatory decisions insofar as the permit, because it's not a license, is the permit, and that must be issued by the Tnpa in terms of the Ports Act, either following a long process, which is stipulated in Section 56, or alternatively, if not Section 56, Section 79 may need to be invoked. So those are the processes that are beyond our control and under the control of another regulator. From our side, we are only guided by Section 16 of the Gas Act. And Section 16 of the Gas Act, which is the one that we're grappling with, the subsection of Section 16, it asks one thing and one thing under item or subsection D, that the applicant, when it submits an application to us, it must provide a description of the proposed facility to be constructed, operated, or the proposed trading to be conducted, including maps, diagrams, where appropriate. So where we are, so we know that these facilities that you are asking NERSA to grant a license for will be operated at the ports. Now, is it your view that what I've just read, it requires NERSA to then wait and get confirmation first from the Ports Authority that it has authorized Karpowership in terms of Section 79 or Section 56 that it can operate those facilities at the ports? It's as simple as that. I want to understand, and here I would like to understand if you have received any legal advice and opinion regarding this specific requirement that is in Section 16 sub D, where it simply requires that the applicant provide a description of the facilities that require a license, the maps, and where such facilities are going to be operated. So is it your view, and have you received any legal opinion and advice that NERSA should not consider your application until such time that NERSA obtains a confirmation that you have been authorized by the ports, by the Tmpa, to operate the facilities? We are grappling with that, and we really need also your views and perhaps any legal advice that you may have obtained in this regard in terms of how NERSA should discharge its mandate as indicated in Section 16 2D. The second question, the second issue that is a concern which we are grappling with is the duration of this power supply contract, the 20-year period. We asked this question previously, but now we want to ask it in relation to what you have submitted to us today, where you stated in your presentation that gas is in transition to net zero. That was your view. And there may actually be renewable gas. So when we say in transition, it's as if that it will never be needed. But the issue there is the methane and is the carbon. So if there's technology that can take care of those things, I wonder if the gas will never be needed in the future if those two things are taken care of. But in any event, for now, it is your submission that it is in transition to net zero. So if it is a transition to net zero, how do you reconcile the 20-year period for the supply contract, the possible supply contract with Eskom? And having said that, what is the status of that supply contract with Eskom? And then the other issue that you may need to clarify to us, because you applied for different licenses, there will be a location where the FSRU is going to be located, but you also have the distribution line, and then also the land at which such facility is going to be located. But also if there's going to be any requirement for you to get permit for the utilization of any land, say around Kucha, if there's going to be that, or Saldanha Bay or Richards Bay. May you please clarify to us what is the status of your request to utilize the land for purposes of locating your facilities for the operation of this the infrastructure that you want NERSA to license. The fourth concern is around the status of the environmental impact assessment. Again, I would like to draw your attention to first what is within our mandate, what NERSA needs to check before we can do a final consideration of your application. In this regard, section 16.2, subsection F, it says that the applicant must include the plans and the ability of the applicant to comply with all applicable labor, health, safety, and environmental legislation. It says you must include the plans. Now, with that requirement, is it your view that NERSA must first see some authorization from the Department of Environmental Affairs that you have been granted the EIA? That's the first question, and we put this very specifically because these are the things that we need to be to answer to specifically. And then secondly, NERSA may also require you to demonstrate that in terms of your plans, to demonstrate that you have actually applied to the relevant regulatory authority in order for you to comply with labor safety and environmental legislation. Can I please ask this other person that has the mic that is unmuted to please mute your mic? Only my mic at this stage will be unmuted. So can you confirm to us that you have made plans to comply with these specific pieces of legislation that I have mentioned? That's what we would like you to include in the application. Can you confirm that you have included it? Bear in mind that we are aware that there was an application and such application was rejected. Then the legal question that remains, which we are grappling with, is whether you still have a valid application that is before these authorities, for which application still needs to be adjudicated on or be determined. Do we have any legal and valid applications on your environmental requirements? Because what we understand is, firstly, is that it was rejected, and secondly, you have informed us that you have lodged an appeal. But is an appeal an application, a plan to comply with this legislation? Would you interpret it to be a plan to comply with this legislation? And then the fifth thing that my colleagues touched on this, and I think in your explanation you also touched a little bit and we asked about this. However, which is the third-party access. The issue with it is that your explanation does not touch on the impact, first of all, the rationale for exclusivity. Our regime is not the one that requires exclusivity. Why do you have the exclusive terms? Because our regime does not require exclusive terms. We don't have that in our law. Our regime is one that says uncommitted capacity. So if capacity is committed by contract, it at least have a lower bar than to have exclusive terms, because one can look at whether or not the committed capacity is being utilized or is simply bought out or contracted out to the detriment of ensuring expansion within the market or preventing others from entering or utilizing the infrastructure. So it is a very different one. So I would like to understand why, first of all, there should be any exclusive terms when it comes to the capacity, the storage capacity that you will be operating. But also, that will go against some of the policy imperatives that NERSA is required in terms of our law to ensure, first of all, the promotion of historically disadvantaged businesses that are owned by historically disadvantaged South Africans. We do have that mandate. It's a policy imperative translated into the law that NERSA must be able to promote businesses that are owned by historically disadvantaged South Africans to the extent that they may want to enter at a trading level, import gas, and so that that gas may be stored in the storage tanks that are on board the FSRU. They may want to do that. Now, if you have exclusive terms, they may be prevented from doing so. So that is just one example. And also, we have the mandate of ensuring or regulating for diversity in the gas supply for energy security, and also to ensure price competition and the promotion of SMMEs. So we feel that at this point in time, any exclusive terms will prevent us from ensuring this mandate. And then lastly, I would like to then understand the issue of, and it is a big concern, and I'm sure you will appreciate it, the price. The price, not just the price of gas, but I think the concern is around the price of electricity that is generated through this facility. And the solution, you may say that it is a quick solution and it will ensure flexibility and sustainability, but it comes at a cost. And whether the cost should justify such flexibility and sustainability, at what expense, and to the detriment of, should it be to the detriment of the South African customers that then they pay that much for this? So those are the questions that we need to look into as NERSA and get responses. May you please respond? We're giving you 10 minutes to respond. If I think the questions, all of them are clear, also from my colleagues, and some of them you may want to respond in writing, but we need to receive your responses within the next 7 days. But for now, you can just touch at a high level in terms of your response. Thank you.
Thank you very much for the questions. I will try to answer as much as I can on a high level. But I think we need to address some of these on a written basis to go into more details. First, I will start with Mr. Mkize's questions. First of all, financial clause, where are we? On the financial clause, as this is an ongoing procurement process with IPP office, we are constantly in discussion with IPP office where we are in terms of our readiness to financial close. And these processes, Section 79 and environmental appeal are the two important authorizations that we are waiting, and we constantly report back to IPP office on these ones. And we also report from time to time to NERSA and to other authorities as they are also seeking clarity. So I can confirm that there is our Section 79 application is not declined, but it is delayed. And as we have received your request for urgent information, we have engaged with Ministry of Transport and Ministry of Public Enterprise, and most importantly, the SIP committee, SIP 20 Committee of Presidency. I think SIP office mandate here is, because these are all strategical infrastructure projects, they have the right to, they have the duty to coordinate between different governmental authorities, and our engagement with them for several, we have regular weekly meetings with them where they update us where they are, the different governmental authorities. We have been told by them that there are no issues or there are no obstacles in front of our Section 79 application. It's more a time-consuming consultation process that they are going through. So we believe we would be reaching financial close as quick as we receive these applications. As I tried to explain, the DFFE, the environmental authorization process, is beyond the timelines of the regulation. So as long as we receive those, which we hope to receive in the next couple of months, for sure, the current timeline is in June, environmental application timeline from the independent expert, then we will be able to continue and reach financial close. That's where we are on the process. On the vertical integrated solution part of it, I mean, we understand the ability of the other players in the segment, but this is not only an FSRU play. When you bring a key infrastructure like that, and there's a whole value chain which actually we don't have any interest to be a party, and we believe there will be many other parties who would be filling those gaps and investing into those new jobs. That's, I think, the most important part of this. And this is the third question. Second question is about exclusivity and third-party access. I think the letter that we sent to NERSA, I think it was yesterday, where we have co-signed with Shell, I think we showed our commitment to look this upfront at this exclusivity issue. And I think this exclusivity issue is also is another question more in detail from Ms. Maseti. I think the exclusivity is binding for us and Shell, between Karpowership, South Africa, and Shell. And the reason is we give the right to manage our storage to Shell so that they could deliver LNG as per their plans, as long as they fulfill our commitments towards ESCOM for dispatchability. That is the exclusivity arrangement, and we commit to Shell that we would buy any additional LNG for our MIPP program from Shell. But the exclusivity doesn't bind NERSA, or I don't think it is directly related with our gas applications. One relation is obviously the storage, and can we give third-party access? As of this letter that we have submitted, we are happy to reconsider that provision, which is between us and Shell, and to discuss open storage for other parties as well. That is something that we are happy to discuss, because we want to deliver these projects on time. Fourth question was 20-year period and the licenses. The 20 period, as I said, is for the PPA, is for the power, is not for the gas side necessarily. Obviously, we need to have all of our licenses for the contract term, that's what we are doing with Tmpa as well. But in the implementation agreement, government has the right to cancel those if they want to. For Ms. Sitole's question about safety, in our gas operations for the power ships around the world, we don't have any incidents. So we can provide our safety track record as well. We don't have any issues or challenges in terms of safety. And LNG industry is a very advanced industry in terms of health, safety, and environment, that I can assure you. Mr. Guedes' questions about gas supply for power generation owning the feedstock. Yes, as a requirement in the PPA, you need to buy the LNG and buy gas, LNG, diesel, HFO, and sell electricity to ESCOM. Your question, an economy in the world that have gas in the energy mix. Yes, there are some economies, but not any, as far as to my knowledge, there is no developed country which doesn't have gas in their energy mix. Third is the terms of the PPA. Yes, in our PPA, there is an availability, a capacity payment, and there is a gas payment, which are separate charges. That's why government has the option to cancel the gas portion and can supply theirs. And our gas price is very transparent in our financial model and our submission to IPP office. And I think this question requires a written answer, but obviously we have discussed this section 16 of Gas Act and its subsection to provide a description and our ability to comply, which we believe we do. As this particular point has been raised and has been discussed during our power generation license applications to NERSA as well. And in the justification document of NERSA for the power generation, this has been addressed as well. I think we comply, we can confirm that we demonstrate our ability to comply. And the environmental appeal is definitely an application which is pending and which is still valid. That is also being discussed with IPP office, which is running this procurement progress. Still, I'll check if we have any legal advice or legal opinion, but we will definitely on this matter get back to you on a written basis. Apologies, I sincerely apologize that I didn't know that we have still outstanding questions which we haven't replied. As you have confirmed, we have replied to certain questions. I wasn't aware that there are certain questions that are pending, but we will definitely get back to you in 7 days after this hearing. Duration of power supply contract for 20 years. Now, there is an integrated resource plan, which shows the path to go to net zero emissions. And this is a transition, yes, but power industry, energy industry in general, is a long play. A 20-year transitionary power plant is actually, when we call transition, it's not to go to net zero in 5 years. I think the target here is 2050 to go to net zero. We are in 2022. I think these solutions, this RMIPP program for 20 years, plays those transitionary role in my mind. For the different licenses, FSRU located in those ports, yes. In our port agreement with Tmpa, we basically cover all the utilized areas for our facilities, which is Karpowership, FSRU, and the gas pipeline in between. On the cost side of it, I mean, this is a risk mitigation program where government asked for 16.5-hour dispatchable power plants, which should be built in 12 months. When you add these requirements on top of each other, I think the prices that have been achieved here are very, very competitive. I've been working in this for many years, and you could have benchmarks around the world for similar requirement tenders. I believe the prices that have been achieved here are very competitive, both for capacity and for fuel and in total cost of electricity. And if you look to the general total mix that in the IRP and in ESCOM plants, I think the 2,000 megawatts we are talking here is a drop in the ocean, is a very small part of it. And for the inclusion of historically disadvantaged South Africans for the supply chain and for third-party access, as I said in our letter, we are happy to consider these requirements for usage of our infrastructure by additional parties. But as you may imagine, in order to compare our obligations to ESCOM and these third-party access requirements, we need to understand the real demand. Is it the storage? Is it regasification? Is it gas supply? Is it LNG supply? Then we would be able to factor this in our design. And as I said, we are happy to reconsider our design and have different specifications on the FSRUs and try to accommodate all those needs. I want to underline once more, the exclusivity discussion is between Karpowership South Africa and Shell, and it's a commercial discussion. It is not an exclusive arrangement. We are not asking for a license which would be exclusive in terms of third-party access. And we said we are open to discuss these with yourselves. I hope I covered most of it, and I will try to go through once more my answers, and if not, if I haven't covered, we will try to get those answers to you by written basis.
Thank you very much, Mr. Katma. Please provide additional responses in writing, because the questions, there were a number of questions, and I think the responses they may not be adequate to in certain respects. So if you could kindly provide us additional responses to all of those questions in writing in the next 7 days, please. Thank you very much for your time.
Thank you.
All right. Thank you so much. Colleagues, we are now moving on to the next presenter, and that is Mr. Adrian Paul. He's from Adrian Paul Attorneys, and he's representing the Green Connection NPC. Can we see Mr. Adrian Paul?
Good morning.
Good morning, sir. All right. Do you have any objections in taking the oath?
I don't.
No, you don't have. Okay. All right. So I assume that your submissions will cover both legal arguments, legal submissions, and the facts, and that is why you are willing to take an oath or are making an affirmation.
To some extent, yes. I'm standing in for Liz McDade, who's currently overseas. So for that reason, I've been mandated to make the Green Connection submissions on its behalf.
All right. Thank you very much. May you please then raise your right hand? Do you solemnly declare that the facts you are going to present before this panel today is the truth and the whole truth?
I do.
Thank you very much. May you please state your name and your designation at Adrian Paul Attorneys, as well as your capacity today in terms of your submissions.
Well, my name is Adrian Paul. I'm the sole proprietor of Adrian Paul Attorneys, and I'm mandated by the Green Connection to make these submissions on its behalf.
Thank you very much. You may start with your presentation, sir.
Thank you very much. I won't be using a PowerPoint presentation. I'll just be speaking to the submissions. Just as a start, the Green Connection is an environmental justice organization that's obviously concerned with long-term sustainability, in particular relating to energy and fossil fuels and the usage thereof. As a starting point, just to provide context, of course, the National Energy Regulator has various duties under the National Energy Regulator Act, including to act in a justifiable and transparent manner in exercising its discretion, to act independently of any undue influence or instruction, and to act in the public interest, amongst other things. In terms of its decision-making, NERSA is, of course, required to make its decisions consistent with the Constitution, again in the public interest, and in accordance with procedurally fair processes. And just to remind us that in terms of the Gas Act, the objectives of the Gas Act, amongst other things, are to promote the efficient, effective, and sustainable usage and storage, transmission, etc. of gas, and to ensure the safe and economic and environmentally responsible transmission, distribution, storage, liquefaction, and regasification of gas. My submissions today are really just to amplify some of the issues raised in the written submissions made by the Green Connection in response to the initial notice that came out earlier. And we'll start with the environmental authorization issue. I think the most important point that we would like to amplify in this regard is, of course, that on the 23rd of June 2021, the Department of Forestry, Fisheries and Environment issued records of refusal in respect of the 3 Karpowership applications. So the implications of that are that the having refused the environmental authorizations, the Karpowership companies, in our view, are unable to show compliance with the applicable environmental legislation. While it is correct that The Karpowership companies have appealed these authorizations. Various organizations, including the Green Connection, who were interested and affected parties in the EIA process, have of course responded to those appeal grounds, and we believe that there are very good grounds upon which the appeal will be dismissed. That's the Karpowership's appeal. Those issues, of course, deal with various issues that haven't been traversed in this gas license application, including, amongst various others, issues relating to underwater noise predictions, the inclusion of additional information after the interested and affected parties had been afforded an opportunity to make comments, the potential impacts of the Karpowership operations in the ports on ecologically sensitive areas, on fish breeding grounds, the knock-on effect on juvenile fish, and what that means to, in particular, parties and small-scale fishers and small-scale fishing communities that rely on fishing for their livelihoods, as well as other industries, including in Saldanha Bay, the aquaculture industries. So we believe that it would be irregular for NERSA to proceed to grant these gas licenses, given that the department or the department responsible for environmental affairs has refused the applications. That is where we currently stand, and there's, of course, the decision is now in the hands of the appeal authority, and not within the power of the Karpowerships. The fact that it's made an application, well, that it's submitted an appeal against the decision, doesn't take that matter forward at this stage. And we believe that it would be more appropriate for NERSA to wait for the department to make its decision. If the refusal is upheld, there's certainly no need for any of these licenses. And we would also like to amplify that in addition to what was referred to earlier in terms of the plans and ability to comply with, amongst other things, environmental legislation, the objects of the Gas Act, of course, as I mentioned, include ensuring the safe and environmentally responsible transmission of gas. And we also would like to amplify that, of course, the NEMA Section 2 environmental management principles apply to the actions of all organs of state that may significantly affect the environment, and that those management principles need to be applied by NERSA in considering this application. But certainly in the face of a rejection of the authorizations, we believe that it would be improper to proceed, and that would expose the license to potential legal challenge. To move on, one of the other significant grounds of complaint raised by the Green Connection was the redaction of significant portions of the applications from public scrutiny. If one goes and has a look at the application forms, they're replete with blanked out sections. And that, of course, extends to critical issues such as the power purchase agreement and its terms. So we don't know, as the public, and of course that goes to the issue of transparency, which is a constitutional imperative in this country, amongst other things. We don't know about the mandatory minimum offtake provisions and what the cost implications of these will be, and whether and to what extent those will be passed through to electricity users. And of course, we are concerned as an the Green Connection is concerned as an environmental justice organization about those implications, especially for disadvantaged and vulnerable electricity consumers that can't afford expensive electricity agreements. In addition, the fuel supply arrangement between the Karpowerships and Shell has not been made public as far as we're aware, and we certainly haven't been afforded an opportunity to comment on them. We know that a Karpowership subsidiary company has been established to deal with this. We don't know what the cost implications of that are, what the implications are of the Karpowership companies entering into an exclusive fuel supply or gas supply agreement, or what the terms of those agreements are, and other important issues such as whether the price of the gas is indexed to the US dollar commodity price for LNG gas or not, and what those implications are, not only from a point of view of volatility of the gas prices internationally, but also in terms of what might happen if the South African rand continues to devalue against the US dollar in those circumstances, and what that would mean over a 20-year period for electricity users who will ultimately bear the costs of the electricity generation and the use of gas to do so. So in a nutshell, we believe that insufficient information has been available for the Green Connection and other interested and affected parties to be able to comment in an informed and meaningful manner on this application, and in particular with regards to the potential negative implications of those arrangements, such as I mentioned, potential price fluctuations or devaluation of the rands, and what that means to electricity consumers who ultimately bear the costs of this. We believe that if NERSA moves forward and approves the licenses within this context, that would constitute administratively unfair decision-making and would again be vulnerable to legal challenge. The third issue that we would like to highlight relates to the 20-year lock-in period that's been discussed and questions raised on earlier. So in particular, we would like to amplify the issue of some of the economic implications. In our view, or in the Green Connection's view, South African electricity users will likely be burdened with the costs of the Karpowerships over the 20-year period, which is a particular concern if the power purchase agreement with Eskom includes a minimum offtake, which we believe it's likely to do, which of course extends well beyond the short-term supply gap that has been identified and which the risk mitigation project seeks to fulfill. This period, as you know, extends to 20 years, whereas it's probably likely that the short-term power gap should be addressed within the next 5 years at the most. Also, when one looks at the Karpowership economic arrangements, it's clear that the main cost element for the Karpowerships is not capital cost. Of course, the Karpowerships will remain the property of the Karpowership companies and will not be an asset in this country, but would then be free to leave or be removed at the end of the contract period. But the main cost element, as shown in the various documents, is of course gas. And the concern is that South African electricity consumers will be required to pay more over the 20-year period in order to make the tariff more affordable in the short term. So while it may be justifiable to increase costs to fill a short-term electricity supply gap, what essentially we're having is a situation where you've got higher tariff over the 20-year period, where if we say 15 years of that is no longer the short-term gap that needs to be addressed, essentially future electricity users will pay a substantial premium to subsidize the benefits in the short term. We believe that transparency is required regarding the imposition and details of the minimum dispatch commitment over the 20-year period, as well as in regards to what the future costs will be, as well as to what the benefits might be in the short term. But again, because of the redaction of the information, and which, as I mentioned, includes the PPA, the gas arrangements, as well as what was referred to earlier as the implementation agreement with government, which we, as interested and affected parties, haven't seen either. We're not in a position to be able to comment meaningfully on those, other than to raise general concerns as we have. We therefore, as the Green Connection, respectfully submit that NERSA needs to consider those economic implications of granting the various gas licenses to the Karpowership companies in order to discharge its duty to act in the public interest, to ensure that its decisions are consistent with the Constitution and all applicable laws, and to ensure that its decisions are in the interest of both current and future generations and the public in general. The other issue that we'd like to amplify in relation to the 20-year lock-in period relates to the issue of climate change. The Karpowership project is estimated to generate cumulative emissions of up to 54 million tons of carbon dioxide equivalent over the 20-year contract period, including emissions of methane gas, which are part of the liquefied natural gas, which are estimated to be 86 times more potent than carbon dioxide over a 20-year period. The International Panel on Climate Change has indicated, for example, that methane emissions need to be reduced by about 40 to 45% by 2030 in order to keep global warming below 1.5 degrees, and that deep cuts are needed to achieve this. What we have, of course, here is a 20-year period, so we're looking up to possibly 2042 or 2043, depending on when and if, assuming that the Karpowership started in 2022, the period would run until 2042, which would then lock us into those emission scenarios. We'd also like to highlight that South Africa's energy sector currently is estimated at contributing about 84% of the country's overall greenhouse gas emissions. And we submit that the increased use of LNG gas through, in particular, the Karpowership project over this 20-year contract period will inevitably add to South Africa's greenhouse gas emissions, which is a significant concern given the climate crisis that's internationally recognized, as well as South Africa's commitment to work with others to ensure temperature increases are kept below the targeted levels, above pre-industrial levels, in order to achieve net zero by 2050. No information, as far as we can see, in the redacted applications was provided indicating the extent of any impact the Karpowership projects would have on South Africa's ability to meet its international climate change commitments, including its revised nationally determined contributions. The Green Connection also anticipates that carbon taxes, both nationally and internationally, are likely to increase over the coming years, while internationally measures are also aimed at curbing trade in carbon-intensive goods, and imports from carbon-intensive jurisdictions are also likely to become more common. The Green Connection believes that this increases the risk that the Karpowership project's use of fossil fuels will become increasingly more expensive and unsustainable over a 20-year contract period. For these reasons, the Green Connection again respectfully submits that NERSA needs to consider the climate change impacts or implications of granting the various gas licenses to the Karpowership companies in order to discharge its duties to act in the public interest, to ensure that its decisions are consistent with the Constitution and all applicable laws, to ensure that its decision is in the interests of current and future generations and the public in general. We also submit that NERSA also needs to ensure that it has regard to and is guided by the NEMA Section 2 environmental management principles when considering its decisions on the Karpowership gas license applications. Thank you very much. Those are our submissions. As I mentioned, written submissions were also made, and these merely amplify some of those aspects. Thank you.
Thank you very much, Mr. Paul, for your submissions. I suppose maybe some of my colleagues will have some questions of clarity to ask. And I would then request you to have a piece of paper and a pen to take down the questions. Members, if you have any questions to ask, may you please raise your hands, starting with Mr. Mkhize. Please go ahead, Mr. Mkhize. There are no other hands from the members of the public that will be allowed to ask questions to the presenter. I've indicated the procedures of this hearing right at the start. If you have any questions, please send an email to Mr. walter.mabunda@nersa.org.za. He is constantly monitoring his emails so that he can forward the questions to us. Please utilize that option. Mr. Mkhize, please go ahead.
Thank you, Chairperson, and thanks, Adrian, for the presentation. I just got about 5 questions. One is that I just like to check if you are in, maybe to say, what is your view with regard to NERSA's position with respect to the governing legislation regarding this project? I'm saying that particularly in terms of the Gas Act, Section 16, 17, and 18, regarding license applications, to ensure that the process is not delayed from NERSA's side, but taking due regard of the fact that even the conditions of the license, they require compliance with other laws in line with Section 21. with Section 21(2)(a) actually enabling any aggrieved party to then require that the conditions be reviewed. So that NERSA has got a specific mandate that must be viewed in one space, as opposed to then getting into the terrain of other regulators, to allow the other regulators freedom to do their work, whilst NERSA is focused on what the law prescribes it needs to do. What is your view with regard to that kind of proposition or stance with the regard to this application in particular? And then also I would like to know your appreciation of confidentiality as it is enshrined in our constitution and law, in particular the protection of confidential information, especially at a crucial stage of this project, as you talk of the redacted sections of the information that is shared with the public. And then you alluded to the fact that at the end of the contract period, there won't be an asset thereafter for South Africa to use. I would like to invite you, if you have any calculations to the fact that there could be a solution beyond the 20-year period that offers useful and usable assets beyond that would come at a lower price, maybe to then, maybe if you can assist in that regard. Because when it comes to this part, you seem to be looking at 20 years as a short period. But when you talk, you are saying that 20-year period is short, but you seem to be saying it's long, because you are saying that we are going to be locked into this for a long period. So I don't know when this period becomes long or short in your perspective. It's just a bit of, I'm trying to reconcile these things in my mind. So if you can help in terms of the reconciling of these things in my mind. And lastly, when it comes to the issue of the greenhouse gas emissions for electricity generation, aren't you of the view that the country has already provided other alternatives in terms of renewable energy, to the extent that the country has positioned itself in terms of the white paper on energy policy of 1998 to say that they're looking at the energy mix, and if there's an increase also in the renewable energy without also much subsidization from government, looking at what they've done, will this not result in a low contribution in any event, with all other initiatives like the reduction of registration requirement to allow 100 megawatt and other initiatives that will then assist, without necessarily saying that there is no space for gas in the energy mix of the country? Just like to get your views around that. Thank you.
Thank you, Mr. Nkisa. Ms. Sithole? You unmute, Mr. Sithole, please. Unmute yourself.
Oh, apologies, Chairperson. Thank you, Chair, and thank you, Mr. Paul, for your presentation. And I just have one question. In your presentation, you indicated that NERSA should wait until the required authorization processes are dealt with. And my question is, what is the legal basis for this, taking into account NERSA's regulatory mandate in relation to this particular application? Thank you, Chair.
Thank you very much, Mr. Tole. Mr. Kumet?
Thanks, Chairperson. Mr. Pope, I've got two questions for you. Maybe the second one might be a little bit unfair, seeing that you're a lawyer, but the first one, I think it goes straight into your alley. Do you believe that NESA's licenses are predicated on other authorities granting their approvals in terms of their own laws? If that's your belief, or rather in terms of the law, as you're understanding the law, can you kindly maybe indicate to us which provisions of the Gas Act or perhaps the National Energy Regulator Act would NESA be drawing such powers from? I'm hoping the question is clear, sir. Really just to say, as you know, in South Africa, we have multiple regulators regulating water, regulating air, regulating our environment, regulating labor, and so forth, and even tax. Do you believe that before NESA grants a license, all those other authorities that have got, in terms of their own laws, that need to also perhaps come into the fray? That does NESA need to, that before NESA grants any of its licenses, that all those other authorities must have granted their authorizations, or that in fact NESA has got powers to ensure that all of those other requirements are met in granting its law, in granting its license. And in so doing, where would you believe that NESA draws that power from? That would assist us, I think, as NESA. So that's the first question. The second question, as I indicated, is a question that I'll ask all of the presenters. Maybe frame it slightly different for you. But in respect of all economies of the world, perhaps the question, I'll put it this way: is there any economy in the world that you know of that only has one form of energy in its mix? Is there any economy, especially developed economy, that is fully functional economy, that is reliant on just one form, whether it's hydro or geothermal, but does not have a balanced portfolio in terms of its energy mix? And in particular, is there any economy that does not have gas in its energy mix? And I know some others might just be 95% gas, others might be 2% gas, but there is a portfolio. Is there one that, in your understanding, that does not have any gas in its mix and that is fully reliant on just perhaps, say, solar and wind? Thanks.
Thank you very much, Mr. Kumete, for your questions. I just want to just add on the question, just to clarify it, and also just assist in just Mr. Paul to help us fully understand the mandate that is articulated clearly in section 16, sub 2, sub F of the Gas Act. So it has two requirements, and we really would like you to explain to us, given your submissions today, the extent of our mandate articulated in section 16 sub 2 sub F, and as well as sub D. The first one on sub D, all it requires, and it talks about the application for license, and it says that the application that is brought before us, as contemplated in sub 1, must include, then sub D says it must include a description all it requires a description of the proposed facility to be constructed or operated, or the proposed trading to be conducted, including maps and diagrams, and any other requirement that is there insofar as the location of the facilities are concerned is simply the principal place of business of the applicant, which is in sub A, and then sub D only mention that the application must include the maps as well as the diagrams where appropriate. That's what we're working on here when it comes to these facilities being located and operated in the ports. That's the only empowering provision we have. The second empowering provision that we have for purposes of a license that we always and we need to look into is F. Insofar as your submission goes, that NERSA should rather wait for the outcome of the appeal. Now, what this section says, the application that we must consider must include the plans and the ability of the applicant to comply with all of the applicable legislation. And those pieces of legislation mentioned therein is labor, is safety, is health, and environmental. So can you then, in your view, just clarify if this so can you clarify whether then our mandate requires us then to first see any authorizations being granted by the regulatory authorities responsible for administering these pieces of legislation, health, safety, labor, and environmental legislation? Must we first see confirmations that they have authorized? Is that appropriate for NERSA to wait for confirmation of authorizations? Is it what is required here? And if you can clarify, because that's exactly the issues that we are grappling with. So I would like to leave it at that, but I thought that it will assist just to read out those specific legal requirements that we need to pay attention to as NERSA when we are processing the application. Over to you, sir. You may respond. You are on mute, sir. If you can please unmute yourself. Thank you.
Thank you for alerting me to the fact that I was muted, and thank you for the questions. I hope I've written them down properly. As far as I understand, the first question from Mr. Mkhize was, what is the Green Connection's view regarding NERSA's position on governing legislation, section 16, 17, 18, regarding licensing applications to ensure there's not a delay from NERSA's side. He spoke to NERSA's mandate in one space and entering the space of other regulators, and whether this overlaps. If I'm not mistaken, that's similar to the question raised by yourself, Chairperson, relating to the mandates articulated in section 16(2)(f) and section 16(2)(d). So obviously it's quite a complex issue, and of course comes down in part to interpretation of those specific provisions. But as I stated in the beginning of the submissions, any decision made by NERSA, obviously there are specific provisions in section 16 which relate specifically to what needs to be in the license application. But of course NERSA is also guided and empowered and bound to some extent, where appropriate, by the duties imposed on it by the National Energy Regulator Act, the objects of that act, as well as the Gas Act. And those, as I mentioned earlier, include issues relating to ensuring, for example, under the Gas Act, ensuring the environmentally responsible transmission, etc., of gas. It also deals with various other issues. But I think what we would like to, as the Green Connection, amplify here is that we're not dealing with a situation where you simply have other departments that are within their discrete mandates considering applications and processing them. What we have in this situation, I think there's at least two, and of course we reserve the right to raise additional issues, but there's at least two issues that are of critical concern. The one is that it's not as if the environmental department is processing the environmental application by the Karpowership companies. The applications were refused, and that is critical. So the question then becomes, in light of the department whose main responsibility is to assess the environmental impacts and to grant the environmental authorization, in circumstances where it's refused the authorization, is it appropriate for NERSA to then proceed, notwithstanding that? And we say that it's not. And that's not simply because there's a refusal, but because NERSA also has obligations to ensure environmental sustainability, economic sustainability, etc. So it has its own, it needs to apply its own mind under Section 2, and of course it can be guided by the environmental impact assessment process. So we're in a very different world if there was an application simply being processed, or if there was an environmental authorization in place. What we have is a record of refusal. The applications were refused. Now, in our law, it's not uncommon for there to be overlapping areas of jurisdiction, and there's various cases that have dealt with that, such as the Max Sands case, where different organizations with different focuses from the empowering legislation still need to make their decisions, and there's not necessarily a conflict between the exercising of those powers, even where they overlap. The important thing here as well is the fact that in looking at these licenses, given that there's an environmental refusal, obviously the Karpowership companies have submitted an appeal, and some of that has been included in their application forms. What's not included in the application forms is the responses of various interested and affected parties opposing that appeal, all of which we submit should be taken into account by NERSA. But if NERSA wants to proceed and process the gas license applications, notwithstanding the refusal from the Department of Environmental Affairs, or Forestry, Fisheries and Environment as it's now called, then it certainly needs to satisfy itself to all of those environmental issues. And we also perhaps just remind NERSA that there are also other principles and considerations that it should be taking into account, such as harmonizing its policies with other departments, like the Department of Forestry, Fisheries and the Environment, etc. So in our view, in this circumstance, having regard to this particular project, the fact that there's records of refusal should be an indication to NERSA that it should at the very least wait until the appeal process is completed. We don't see that there should be any prejudice to anyone from this point of view, and if NERSA is considering that this may cause more problems for the Karpowerships to achieve commercial closure, we would encourage you to consider whether that's an appropriate consideration for NERSA to be taking into account. We've also seen those commercial closure dates be shifted constantly by the Department of Minerals and Mineral Resources and Energy, so we don't think that that's necessarily a critical issue. Moving on, with regards to confidentiality, as with any other constitutional rights, there's the right of access to information, and there are also restrictions on those rights. As the Green Connection, we're not interested in commercially sensitive information that may be damaging to the commercial interests of Karpowerships insofar as it has other competitors are concerned. But we also have the right to administratively fair procedures, and part of that is the right to be provided sufficient information in order to make informed and meaningful comments. In other words, to make that right real and not an illusory one. Now, when all of these, copious amounts of the application papers have been redacted, it's almost impossible to follow when you go through the documents exactly what's in them. But more importantly, when it comes to critical issues relating to what is important for the South African public and the civil society, which is, for example, the costs that will be passed through to electricity users over the 20-year period, we believe the rights of interested and affected parties should, in those circumstances, override the rights of Karpowership to want to keep such information confidential. In terms of the relevant legislation, we understand that obviously the Karpowerships can apply to keep information confidential, and that NERSA would then make that decision. As interested and affected parties, we certainly weren't consulted on that. We had no opportunity to make representations on what would be appropriate and not appropriate. But just having a look again recently at refreshing myself as to what was in the applications, it's clear that these copious amounts are simply redacted. We don't know exactly what was redacted. We don't know what was, it makes it difficult to work out what should have been in and what shouldn't. But we certainly believe that the redaction of critical information that's important to the public and in particular electricity users over this 20-year period should be open and should be made available. It doesn't have to include every single detail, but those aspects, there should be sufficient information provided in order to enable interested and affected parties to be able to understand what they're commenting on, to make informed comments, and to seek expert input where appropriate, without unnecessary assumptions having to be made in order to get that advice. Moving on, regarding the no asset after the contract period, the point we were simply making is that in the particular circumstance of the Karpowership situation, the main costs of the Karpowership project is not capital costs, it's the costs of the gas. So when one looks at for example, the other applications in the RM4P, the major percentage of their capital was, of their costs was a capital portion, whereas when you look at the Karpowerships, it was, I think, about 56%. So the major portion was gas. So moving on, with regards to greenhouse gas emissions and other alternatives, you mentioned, mention was made of renewable energy and South Africa's position and the 1998 energy policy and an energy mix. Now, of course, there's no dispute that an energy mix is appropriate. The question is, what energy mix is appropriate? It certainly doesn't mean that every single energy technology is appropriate, especially if it has significant environmental impact and economic implications that other options don't have. And when you're looking at the 1998 policy, yes, that's a guiding framework. We still don't have an integrated energy plan. Section 6 of the National Energy Act still hasn't been brought into effect, which creates a policy vacuum that we're unfortunately still dealing with. But in this project-specific situation, the fact is that we don't believe that South Africa should be locked into 20 years of gas, liquid natural or LNG gas emissions from both an economic and a climate change point of view. Since 1998, the world has moved on. Certainly from a climate change point of view, in more recent years, there's been international acknowledgement and better understanding of the climate crisis and the need to take urgent steps to intervene in that. And the issue of fossil fuels and the usage of fossil fuels and the important cuts that are needed, in particular, including to reduce methane gas emissions, which are associated with LNG gas use, have been highlighted. And if we're going to achieve those reductions internationally and make our contribution to that, it doesn't make sense in order to try and fill a short-term energy gap to then fill a 20-year, or to then extend it over a 20-year period where we locked into higher greenhouse gas emissions, and in particular in this case methane gas emissions over that extended 20-year period. We do encourage, we are encouraged by things like the 100 megawatt embedded generation lift relating to licensing, and of course as the green connections support renewable energy options, which we believe are the best options for the future of South Africa. But that doesn't, of course, mean that one doesn't have an energy mix, and we understand the need for a transition, but we don't believe that gas is an appropriate transition fuel given its climate change implications and other issues. Ms. Advocate Sithole spoke about NERSA, the issue of whether NERSA should wait until other regulatory processes have been finalized and licenses have been granted, and what the legal basis is for this. Again, I think that kind of overlaps with what was raised in relation, including to Section 16. Again, we're pointing out that, yes, there are different processes and different licenses that will be processed, but there are certain licenses and authorizations where there is an overlap of functional areas, and in particular, that includes environmental issues, where there's an overlap of environmental issues. So we believe that the environmental authorization issues are, of course, regulated under the National Environmental Management Act and its regulations, but we also believe that the NEMA Section 2 principles apply to NERSA in discharging its duties and the objects of the NERA, the National Energy Regulator Act, as well as the Gas Act. And for those reasons, when the main functional department has refused the authorization, we believe that it's irrational to proceed and grant a license in the face of that. It certainly also seems to go against the requirements for harmonization of policies between departments, coordination, etc. And then I think it was Mr. Gumede said that he doesn't believe NERSA's licenses are predicated on other authorities granting such approvals. Again, I think I've already responded to that. Here we again have a refusal. We have the harmonization of policies that's required and an overlap to some extent of those environmental responsibilities. And yeah, perhaps I should just also mention that in raising this, we're also cognizant of the reasons for the decision in the generation license applications, where NERSA seemed to suggest that it didn't need to consider environmental considerations. And we certainly don't agree with that and think that it is required to do so. Regarding the economics of using one form of energy and it's mixed, I don't think in anywhere in our submissions the Green Connection has suggested there should only be one form of energy. And with regards to gas, whether that's right or wrong is a policy issue that has to be dealt with at a higher level. As I mentioned, one of the gaps in our law currently is that Section 6 of the National Energy Act still hasn't been brought into effect after almost 15 years, which means that we don't have a lawful integrated energy plan in accordance with Section 6, which should be guiding decisions on things like energy infrastructure development, et cetera. So that is a problem, but it's an issue that's a broader policy issue. What we are focusing on here is, of course, the Karpowership project and its economic and environmental issues, insofar as it relates to the NERSA licensing process in the context of the record of refusal granted by the department. I think that I've dealt with most of the, if not all of the issues, so I'll leave it there unless there's further issues for clarification. Thank you very much.
Thank you so much, Mr. Paul, for your submissions as well as the responses that you have provided, including the clarification on the questions that were put to you. Thank you so much. We appreciate your time. Ladies and gentlemen, we're running out of time in terms of the scheduled time for this hearing. I'm hoping that we will be able to pick up the pace. The next presenter is Black Business Council. I have the name of Carrington Tlali. If I can then have Mr. Tlali. Right. Good morning, Mr. Tlale. Do you have any objections in taking the oath?
Morning, Chair. No, I don't have any objections.
All right. Thank you very much. May you please raise your right hand, and do you solemnly declare that the facts you are going to present before this panel today is the truth and the whole truth?
I do.
Thank you very much. May you please state your name and your designation at Black Business Council for the record, please.
My name is Carrington Tlale. Today I'll be representing Black Business Council in the built environment, the BBC Infrastructure Portfolio Committee. I'm the Vice Chair there.
All right, thank you very much. You may start with your presentation, sir.
Thank you, Chair. Is my screen visible, Chair?
Yes, it is visible. Thanks.
Let's go into presentation mode. What's happening? Okay, apologies about that. It's a bit slow. There we go. Okay. Thank you very much, Chair, and the hearing. Can I, for bandwidth, Chair, just switch off my camera?
Yes, you may switch off your camera. Thank you.
Thank you very much. The presentation today would be from the Black Business Council in the built environment, specifically on Karpowership application on the presented licenses or submitted licenses. Just an institutional overview, Black Business Council has got a number of organizations representing Black business and Black professionals, with Black Business Council in the built environment having specialists businesses and member organizations within the infrastructure sector in various work streams. The Black Business Council in the built environment is an apex organization of Black construction professionals and organizations established in 2007 with the main objective to engage government and other statutory bodies to influence the drafting and implementation of appropriate legislation in order to create an enabling environment for Black constituency in the building and construction industry. So within that interaction with Black Business Council and Black Business Council in the built environment, there is a Black Business Council Infrastructure Portfolio Committee that is tasked to ensuring that there is effective, meaningful and realizable transformation in key economic sectors by supporting projects that will address key challenges being experienced by the country. Energy security is at the top of the list of these challenges, which are adversely affecting and impacting South Africa, especially Black businesses and communities. The matter at hand that is presented in this hearing is the granting of Karpowership's gas licenses to operate in the three respective ports, namely Saldanha Bay, Kucha, and Richards Bay. This is following Karpowership bid for projects in the respective ports to provide a total of 1,220 megawatts of urgent and much needed power to the national grid. Let it also be known that the proposed projects are not only in line with the current demand of energy, but also in coherence with the Department of Mineral Resources and Energy Integrated Resource Plan of 2019, which supports a diverse energy mix that includes liquefied gas, which is what the power ships use to generate electricity. No just energy transition can be achieved without taking into account the importance of liquefied gas to electricity generation and its impact in reducing high emissions that from traditional coal to electricity generation. Anyone or organization that does not believe in just energy transition will also not support liquefied gas as a transitional measure. NERSA at this present stage is required to conduct a holistic assessment of not only the company's gas license application, but also the possible impact of this process. The decisions that end up being taken will surely have a bearing on the future of the country. Our national power generation entity continues to struggle to provide consistent electricity for all its customers, with numerous power station failures that have forced temporary shutdown of generation units. Even emergency power at the disposal of the national power generator is still not enough to cater for the current power shortfall. Also, the cost of the emergency measures are reported to be extremely high and will continue to increase. The severe impact of this decision has been felt by all citizens, ranging from business owners, large corporations, and even health institutions such as public hospitals and clinics. It is also well documented and reported that the current generation stock will not meet the current energy needs of the country. It is also clear that Eskom is under extreme pressure with regards to compliance to emission controls, thus increasing the risk of current coal-based generation capacity being reduced. To see South Africa achieve its goals of a sustainable and lasting energy solution, we need to be practical and act decisively. The RMI 4P process was exceedingly transparent, strategic, and fit for purpose. All the preferred bidders shared the same objective: establishing a secure, stable, and affordable and clean grid that will create jobs and put South Africa on the road to economic recovery. It is very important that we remind everyone attending this hearing that Karpowership has been able to meet the RMI 4P requirements to have a combined operating capacity that will be 1,220 megawatts. It is also worth noting that these power sheds are fully integrated floating power plants that include all the necessary facilities and equipment for power generation. Karpowership SA responded to a tender with specific requirements and provided a solution which was accepted by the DRME as one of the preferred bidders. Karpowership SA didn't create the specification for the tender or adjudicate themselves. The DMRE, through the IPP office, has specialists advising them on the tender and adjudication thereof. This presents a number of questions that are not for the settings. The successful granting of Karpowership's SA gas license will present the company with an opportunity to play a significant and meaningful role to the South African economy. The company has previously alluded to its commitment to spend substantial amount both during the construction period and operation, whilst in the process creating hundreds of jobs. The conclusion of this process, together with the implementation of the RMI 4P project, will also see the opportunity to finalize this potential of immediate economic development and job creation in the country, and significantly impact the local communities that the project will operate in. For several businesses in various sectors, reliable electricity, better opportunities to consistently operate and reduce ever-increasing costs that remain a significant risk towards their survival. Increased productivity and profitability can present them with a chance to actively play a leading role in fast-tracking economic growth, employment creation, and skills transfer. A question will also be who benefits from the current state of energy generation. As we navigate a business environment that is characterized by long-term effects of COVID-19, quick and effective progress in improving infrastructure that include reliable, accessible running water and power is the first step towards recovery. Energy security is the foundation of a sustainable economy, and it is critical for our country to fast-track the implementation of the RMI 4P. The approval of Karpowership SA gas license will present our energy and business environment with a proven energy supplier that already has experience in operating power fleets that operate on natural gas and have the ability to effectively support our high energy demands using state-of-the-art and latest technology at offer. It is also clear that the granting of Karpowership SA license will not negatively affect any future gas license application, but rather offer our country a transitional period to develop and implement an on-land LNG storage and regasification. We are seeing a number of processes being initiated in the country in relation to LNG, thus supporting the premise that the impact is being managed. A number of our business partners and active players are failing to maintain themselves due to high costs associated with operating in an energy-stricken community. It is because of all this that we request NERSA to be measured in its approach and decision to approve and provide Karpowership with the much needed approval to their applications for all the sides. This is the details for Black Business Council in the built environment. I thank you, Chair. I tried to be as quick as possible. Thank you.
Yes, thank you very much. We appreciate that. I'm sure my colleagues will have questions to ask you. I would like to give them the opportunity now to ask those questions. Colleagues, do you have any questions? If you could kindly raise your hand if you have any questions to ask Mr. Tlale. Starting with Mr. Gumede at this time and coming to Mr. Mkhize.
Thank you, Chairperson. I just have one question from Mr. Tlale, and thank you for your presentation, sir. The question that I'd want to pose to you, do you think, is there value or is it even advisable for South Africa to bundle the gas supply with electricity generation? I guess can you confirm that? I think in your presentation, your last slide did kind of allude to this, but can you confirm and indicate your own analysis in this, that in your opinion, granting Karpowership a gas license as well, including basically all of those 5 licenses they're going to be that they are applying for in terms of gas, that it would not sterilize or potentially result in a very dominant gas supplier who might close out opportunities, even for the very black businesses that you actually represent. Thanks.
Thank you, Mr. Gumede. Mr. Mkhize.
Thanks, Chairperson, and thanks, Mr. Tlale, for the presentation. I'm partly covered by Mr. Gumede, because I would say to Mr. Tlale, if you concede to the fact that sometimes good is the enemy of best, do you have any comments in terms of how better or best could this have been arranged such that you don't you reduce certain risks, like the risk of foreclosure going forward into the future, and improving potential benefits to black business in the country, noting the issues that were raised earlier on during the presentation made by Mr. Katma of Karpowership. So I would just like to understand from your side if there's no better deal that could come out of this for the black business in the country or your constituent. Thank you.
Thank you very much, Mr. Mkhize. The question that I have from my side relates to the concerns around the cost of the Karpowership project. And I would like to just understand your views, given the fact that the Gas Act, Section 2, F, so I think it's G if it's not, Section 2J of the Gas Act. It requires the energy regulator to ensure, or at least as one of its objectives, it must ensure and promote access to gas in an affordable and safe manner. So as we promote access to gas, it must be achieved in an affordable and safe manner. Now, given the concerns around the investment cost associated with this project, that will obviously be transferred or translated into the gas price that will be paid also, because we have a trading license. You know, some of this gas could actually be sold to industrial customers. Some of it will be used to generate power. So obviously, then there's a concern with regards to the cost of gas as well as the cost of electricity arising from this project. What is your take on that? Especially if one looks at it from the public interest point of view, but also from the viewpoint of ensuring affordability of the energy that will be generated out of this project. So how do we deal with that concern? And then also, I think the second thing is the safe manner aspect. Yes, the applicant has already stated that it will provide NERSA with information pertaining to its safety, its track record in terms of safety in operating the Karpowerships. However, when it comes to its ability to comply with environmental and safety legislation, we are still grappling with what is it that we need to have before us at this stage of the process. And there are calls that say, NERSA, you need not approve. Obviously, we cannot wait because we've got statutory timelines, which is 60 days after the objection period. And then also after, if there are any objections, then the period changes. So there is no way that the regulator can wait. That one is out because we do have a statutory period and timelines which we must comply with in terms of the law. But the question is whether the energy regulator will be in a position to make a decision that is positive, which is to grant the licenses and that Karpowership has applied for, given the safety as well as environmental issues that are still pending. Do we have to have finality on those issues before we take a decision? Over to you, sir.
Thank you very much, Chair. Let me start with the question from Mr. Gumete. For me, when we viewed this, that it was one of the requirements to have a security of supply, which is one of the things that our current provider of energy hasn't been able to achieve. For you to be able to have security of supply, you have to also have security of source material. And that is why it is important that the gas supply is within the control of the generator. If the customer is happy that a Karpowership will come back and say that your prescribed gas supplier has not been able to deliver gas, so I'm not able to provide the energy that you have provided, then this whole program would be a waste. There wouldn't really be any reason to have this emergency procurement of energy. So for me, I see it as a critical part to the solution, that you have to have control of the source material for generation and generation itself. Then you can hold Karpowership to account fully if they are not able to deliver on their promises or on emergency energy or on energy supply. So that is very important. If we desalinate and break them apart, then you can never hold Karpowership accountable in saying that we are not going to be able to guarantee that the energy, the supply of liquefied gas would meet your demand. So that is so important. But also what it also allows as well is that it has actually broadened up the view of most businesses and Black business for that matter in saying, why are we so then short-sighted in looking at that? Why is Karpowership project then closing up the whole LNG market? Can't we think further than that? And we've seen that thinking coming up in that there is a number of projects that have been announced and inquiries that have been taken out for alternative spaces at the different ports to be created and built for permanent LNG importation. So that means then it doesn't only preclude LNG importation to only this project, but what it offers the country is a transitional period that there is then an opportunity to have immediate LNG importation while a permanent solution for importation is being put into place, which can take up to 10, 15 years to have a permanent solution that will possibly even have an on-land storage. So this is actually an opportunity for the country to align itself properly. And that offers Black business an opportunity to understand LNG importation, storage, through this process that is taking place. And we see it not as being an exclusive mandate, but it allows us to have an immediate participation in the gas sector, which for that matter, Black business has been excluded from, and not necessarily just from being subcontractors and looking for tenders, but to become potential importers of that. So if we see that this process then will exclude a company from actually exposing this whole process, then we might have a major issue with that. I hope that answers that with regards to Mr. Gomet. Mr. Mkhize, reduction of risk and closing out other businesses to have access, but we have seen it that now there is a move to have measures to have other participants, and we know we need infrastructure investment. So this is creating an opportunity that at the various ports that there is now money that needs to be put in to have permanent LNG facilities. So we can't just say that because Karpowership has taken space, now everyone is closed. Our country needs to invest in such facilities. And the fact that Karpowership is available then gives us intelligence with regards to how do we manage LNG importation on a permanent basis, because then we have got Karpowership. And the 20-year period...
But Mr. Sale, if I may come in on that point that you have just made, because it becomes critical for the space for LNG importation, because that LNG importation will come through the ports of South Africa. And in this case, the three main ports have been earmarked by Karpowership. Now, if you look at the scale and even the capacity that is being proposed here, and also the possibility of not being able to have another FSRU operating in Saldanha Bay, or operating in Richards Bay, or operating in the port of Ngqura. Could you have 3 FSRUs in Ngqura, for instance? Could you have 3 or 2 FSRUs in Richards Bay? Could you have 2 or 3 FSRUs in Saldanha Bay? Is that possible? I mean, is that possible? And is it even in the plans that exist currently? Are there any plans that can accommodate more than one FSRU? If already one is challenged with the limited capacity with the proposed FSRU that is in place, without the danger of being stuck with one supplier that is owning, or at least hire this FSRU that is being proposed here, and the only option will then be to expand the tanks that are on board on the FSRU that is the one that came to the market first. In these 20 years, could there be any entry or any investment in LNG?
Chair, I do understand that, but what we need to actually be looking at is that what Karpowership has indicated, that that there is space for this transition period of the 20 years, that they can then open up and possibly increase the additional capacity that they have within their onshore storage, offshore storage. So what it allows us to do is to have enough time as a country to properly explore the need that we have to have additional capacity at our ports for importation of gas. That is guaranteed, because what it means is that then even if you say that the Karpowership can be the only one that is there at this particular point, you would still have got a challenge that there will still have got to be somebody, a central person that is at the port that will receipt all that gas. So it won't be multiple, there will be multiple suppliers of the actual liquefied gas, but there will be a single facility that actually is then operating that. But it gives us an opportunity, and I think that is what we're missing, in that it gives us an opportunity to clearly understand that liquefied natural gas is a measure that we're going to use as a country with regards to transition. But the 20-year period also gives us an opportunity to say the amount of permanent liquefied natural gas that we eventually end up with, would it be at a level that is in 20 years' time when there is reduction in the need of liquid natural gas, which then gives us an opportunity to say that the amount of facilities that we need doesn't have to be at the same level as what we would need now. So for me and for us, we see it as an opportunity for the country to properly look at itself and saying, yes, we have got this constraint, but it is not a permanent constraint. What it allows us to do is to then properly say that if we're going to go a permanent facility, is it going to be a permanent facility that is at what particular level? But in the meantime, let's talk to the DMRE, who are the contract holder through the IPP office, and say, we need then Karpowership to offer additional capacity and access to third parties to be able to access the gas, and at the right preferential rates. So I think that is what is important here. But it goes back to saying then you can't hold Karpowership to be able to deliver the power that they have promised if they don't have control with regards to the gas that they bring in. I think there was also, to you, Chair, the issue around cost. If you look at the amount that Karpowership, the 1,220, within all the gas that is the power that is generated in the country, it is around 2%. So within an energy mix, you have got then those energy items that are at a higher cost, but within the broader cost averaging, then that means, but the benefit that you will get out of it would possibly outweigh the actual unit cost that you have within that. But within the general energy mix, then the general cost would increase, but it wouldn't increase as significantly if it was the only single generation means that was available. So within the general energy mix, and we know for a fact now that we are paying even a higher cost for not having energy. Without even a doubt, we are paying even a higher energy cost because of the load shedding, because of the uncertainty, because of the other salient issues that are related to environments when there isn't power. on the economic factors, on security factors. So there is a higher cost whether we like it or not. With regards to safety, I think we think that it is important that the regulator focuses on its mandate with regards to what it needs to do. And we know we have got a challenge with the multiple interdependencies of the different regulators and different departments, that the efficiency that you would want to maintain within NERSA wouldn't be applicable into other regulators as well. And that in effect, it hamstrung an efficient process for making decisions, but it shouldn't then make the NERSA non-compliant. NERSA still has got a responsibility to become compliant. And our legislations offers every person an opportunity when they are not happy with a decision to appeal it. And we believe that is a process that Karpowership has taken. And we want NERSA to be able to independently make a decision, because the implication of not making the right decisions are much more dire for our country with regards to the energy challenges that we have. So Karpowership is not the all and all solution for load shedding, but it moves us into a direction where we are able then to reduce some of those challenges that we have, which we know for a fact that this year will have more load shedding than any other year that we have had it. That means the implication for that is even higher for the country. I'm not sure if I've answered all of the questions, Chair.
Yes, you did, and I thank you very much for the comprehensive responses to all of the questions. We appreciate your time and the presentation that you made this morning. If there's anything that you wanted to add and you feel that you have not adequately addressed in the questions that have been put forward, please submit your additional responses within the next 7 days. We thank you for that,
Chair. Thank you very much.
So much. Thanks. Right, ladies and gentlemen, before I call on the next presenter, I just want to find out whether there is a presenter called Green Connect. I thought that that is the same presenter as we had on number 3, the presenter, the Green Connection NPC, which was represented by Mr. Adrian Paul. If we have a Green Connect as a separate company altogether, please indicate so. At this point in time, I would like to then call upon Success Way Holdings, and I have the name of Nompumelelo Ndlela to make the presentation on behalf of Success Way Holdings. Please, if we have a person representing Green Connect, if there's a separate company called Green Connect, may you please raise your hand so that we know whether we will have any presentation from Green Connect. Otherwise, Ms. Nompumelelo Ndlela will be our last presenter for this hearing. Ms. Ndlela, may you please activate your camera? Ms. Nompumelelo Ndlela, activate the camera. All right, good.
Thank you, Chair. Can you hear me?
Yes, I can hear you.
Thank you.
All right, before we start, I would like to just inform you that you need to make your presentation under oath, and therefore I need to administer the oath before we could commence with the presentation. Do you have any objections in taking the oath?
No, I don't have any objections.
All right, thank you very much. May you please raise your right hand? Okay. Do you solemnly declare that the truth that you're going to, the presentation and facts that you're going to present before this panel today will be the truth and the whole truth?
Yes, I do.
Thank you very much. May you please then indicate your name and your designation at the Success Way Holdings for the record.
Yes, for the records, my name is Nompumelelo Nosipondlela. I am the founder and the CEO of Successway Holdings. Under our holding company, we have a Successway Foundation that I'm representing today. It is an umbrella body of the SMMEs that we are developing in our economic development firm, mainly in KwaZulu-Natal and all over South Africa.
Thank you very much. You may start with your presentation, sis.
Okay, I will request Chair to share. We have a written formal letter to NESA. Can I share the screen, please?
Yes, you may share if your presentation will be based on that document.
Yes. Okay. This is the document. I hope it does appear on your side there, Chair.
It doesn't appear at this point in time. Mr. Mateja, can you please assist?
Chair, perhaps if she can email us the document she's referring to, we can quickly assist.
Okay, please email the document to walter.mabunda@nersa.org.za.
Okay, let me just quickly do so.
And you may also start with your preliminary introductions as well.
Okay, not a problem. I hope I am winning.
It is showing?
It is showing now. Okay.
Yes.
But I will email Walter as well for the record. Yes, basically, as I was introducing myself, I also represent a number of SMMEs under King Cetshwayo district, which is situated in Richards Bay. And we provide a lot of agricultural programs as well as renewable energy solutions. As much as we develop the farmers, because mainly, as you know, King Cetshwayo is mainly about farming most of the time. So we believe that agriculture as well is an economic program that will take us out of economic crisis. Now, the challenge that we are having as an economic development entity is to empower our SMMEs. And amongst other crucial programs, it is renewable energy solutions. And we have worked with Karpowership, and we are here to support Karpowership gas license approval so that it will enhance and assist number of challenges in our local communities that we are facing. At the moment, the country is facing a challenge. We are in an economic challenge. There is a lot of unemployment, and we are in crisis. And now we need solutions. And among other major crises, it is a power generation crisis. And therefore, we need an immediate solutions and to ensure as well that we mitigate load shedding. We have experienced load shedding, particularly in this region, very, very drastically. Now, as a result, we are under a pressure that we cannot be economic active, even for now and for the future. Now, we believe that if NESA can approve the gas license for Karpowership, it will facilitate and fast-track the economic development for our region, especially Zululand in South Africa. We do therefore represent other provinces, but at the moment we are looking for the opportunities that are very way back for our Black businesses. And as well, we don't even have much Black SMMEs that are entering the energy sector. Now, we have to actually approve to say how, therefore, we facilitate growth to expand our economy from Richards Bay, surrounding areas, and in the region, South Africa and SADC. We have a number of active participating SMMEs in our data, number of stakeholders in our region. We believe that there is a room for improving South Africa economy, but we need to also address the issue of load shedding and energy. Most of the SMMEs have closed down, especially in our region, sadly because of the issue of devastating power and recently COVID and recently floods in KZN, in Durban mainly. Now, with the issue that is at hand with one of the greatest key players that will assist much needed power that can guarantee working conditions for our businesses, for our SMMEs, for even fast tracking the issue of creating job opportunities for our country. And we believe when there is a room for job opportunities that are being created, it attracts as well investment for different destinations. What to mention that Karpowership in South Africa is a trusted entity. I believe they have even presented that they have an LNG fuel solution that can work across the world. And this is one of the technology program that is being required in South Africa. So as we have experienced stated climate change conditions, I believe that having a company that has approved even 3 projects in different regions that have provided almost about 1,200 megawatts power, it is more enough that we should actually consider so that we can reduce at least full stage of load shedding in our country. As a result, such projects will enable different businesses to operate without fear of energy outages and as well of international investment in our country. And Chair, we believe that the recent report from PwC suggests that the country has experienced a collective 859 hours of load shedding in 2020. And therefore, that calculates a whole lot of cost of about 75 billion loss in the gross domestic product. This is a alarming economic challenge that is continuing, and it has continued since 2021 and up until now. And recently, we have experienced a whole lot of amount of load shedding, and we're still going to. Now, it is with this request that we request for Department of Mineral Resources and Energy to also create such a proposed risk mitigating program as well to fill the current shortage gaps of energy. And with the current existing electricity supply constraint, we therefore propose that we should consider Karpowership as a guaranteed energy security organization for even cleaner power energy sources. With such, Chair, as a success way, we acknowledge the concerns that have been raised by different green lobbies, and we believe that while all the parties have their own voices, it should also give other partners to participate and voice their key concern and their concerns regarding to the manner in which we believe that the future that we have for our country and for our region will improve economic conditions, also improve the citizens' socio-economic conditions, and at the same time, all the concerned will work together to mitigate such crises that we are in. pragmatic discussions need to be facilitated in all angles so that we have key departments affected by this project, and namely Department of Minerals and Department of Energy. And we believe that our country does not lose any energy project at this point in time suitable for such a deal. But we encourage deeply and voice our concerns to increase a number of opportunities, to increase the number of job employment and opportunities, to increase the number of business opportunities. The urgent need of innovative ways of such caliber, it will also ensure that we create sustainability in our country. We have a number of unemployed, even young people in our country. And therefore, this is an opportunity for even creating employment and to cater even for them. There is no future if our young people are not employed. Therefore, as I conclude, Chair, I wish to state that Karpowership is the solution and will bring even more stability in our national grid, and will also help entities such as Eskom to overcome such short supply of energy in the national grid. And their LNG-based solution is not does not disqualify renewable energy sources. In fact, it is the complementary energy source, and it's widely regarded as the ideal energy sources for clean dispatching energy, even by economies such USA, UK, Germany, and Norway. Therefore, if they can leverage and benefit the cleaner fuel sources, why does South Africa not do the same? South Africa requires an urgent access to sustainable, reliable energy. If we can have such an opportunity, it is a very good economic opportunity to participate, even after building such businesses that have fatally closed due to COVID-19 economic challenges. Therefore, we need our region to discuss and offer such an opportunity and authority to Karpowership South Africa. And we believe that the EIA submission have been done as well. The company submission have been given attention, and many departments have also given it to attention. Therefore, it takes us to engage Karpowership directly. I thank you.
Thank you very much, Ms. Ndlela, for your comprehensive and very clear message reading out of the submission that you have just made to us before us. I would like to check if there's any questions of clarity from the members of the regulator that are present today. By show of hands, members, if there's any question that you would like to get clarification on. Mr. Tole, followed by Mr. Kumet.
Thank you, Chairperson, and thank you, Ms. Ndlela, for your presentation. I just have one question, and I just want to find out if your organization has had interactions or consultation with Karpowership on how they can provide the SMMEs that your organization represent to get access into the utilization of their infrastructure that your members may need. Thank you.
Thank you, Mr. Tole. Mr. Kumet.
Thank you, Chairperson.
Thank you.
I have two questions for you, ma'am. The first one, I mean, I'm just trying to understand from your membership point of view, or from your company's point of, from your foundation point of view. Are you actually in support of Karpowership gas supply, or are you in support of introduction of a sustainable gas solution into our electricity generation mix? I guess for me there tends to be a bit of a confusion there that says, when we're saying we're in support, are we supporting gas into the electricity generation mix, or are we supporting Karpowership in particular? Linked to that question, I think, I wanted to ask this question to other members. I thought somebody from Green Connect was going to present, but I would like to get your opinion on this. Considering that some people may have concerns around locking the country into a long-term fossil fuels solution again, which might be lower in emission levels or whatever than coal, but still fossil fuel nonetheless. Do you believe that a floating solution, both in terms of a floating storage and regasification coming up, as well as a floating relating gas power, is that a better solution for South Africa than having a land-based solutions? So what's your view? I guess for me, those two are linked. And then, of course, if you don't mind, the last question is, could you kindly explain your comment on a complementary energy source to renewable energy? What's your view? And can you also perhaps begin to educate a number of people, including ourselves, in terms of why the two complement each other, especially in a country like ourselves, which is a virtual electricity island?
Yes, Mr. Kumet. You may respond, Ms. Ndlela, to the questions.
Okay, thank you, Chair. I'll respond starting with Sithole. Yes, we have engaged with Karpowership in a number of programs, and the SMMEs to access Karpowership have been displayed as well on the table, because they believe that such an amount of work will require that mainly SMMEs on the coast and in the region be developed and trained, and especially from disadvantaged background. You'll be very, very shocked that I'm coming from KwaZulu in Richards Bay, and none of the black farmers or any black-owned entity is having a ship asset. Yet there are many ships that are coming in and out Durban and Richards Bay ports, but we don't have black business in owning such. Therefore, if such vehicles that are brought in our country by Karpowership, it will enable our SMMEs to be trained to utilize such vehicles, not just for work, but for even providing a solution of energy in our country. So they would be trained in many dimensions of business, including cleaning, fixing, and also waste management, also many other aspects of such a value chain of a business. So we are looking in a major diverse value chain of energy, and yet it is a very safe method of producing and providing energy solution in our country. I hope I've answered you very well, Ms. Sithole. And when it comes to Mr. Gumede, I want to state that our foundation as an entity under Successway Holdings, it is a two vehicle whereby our foundation supports even training and development of different types of energy matrix. Yes, we believe that at the moment, our country have been very, very one-dimensional using ESCOM. And this is now a high time to introduce other energy solutions in our country. If Eskom is going down, we need solution. And we believe that Karpowership to be granted, that is our support, a gas license to operate, especially in Richards Bay. It is one of the energy solution which is, as they have introduced themselves to us, a renewable one for that matter, because it is looking into a medium of operating in the ocean and using a very liquefied energy solution that is displayed and have a number of productivity that is providing power using such a vehicle over and time again. So given an opportunity to exercise as such, even other countries, as I've mentioned, that have been using Karpowership as an energy security company, it is an opportunity because there are many other aspects of renewable energy. But we're looking into how many megawatts of power are enough for our country to run business, to feed millions of homes, to reduce even the lowest load shedding that we are having in our country. So given it such an opportunity, it will assist that we improve our country competitively and also teach, because we are a growing country as well. We need different types of energy security metrics. Therefore, if such by Karpowership can produce enough energy for our country, why don't we give the opportunity? Thank you.
Thank you very much. I think there was a question, the last question from Mr. Gumede with regards to the complementarity of gas and renewables. And perhaps you may want to touch on that before you finalize your response. In terms of gas being a complementary source of energy to renewables, what's your understanding on that? Why do you think they can go hand in hand, those two, and one is not supposed to substitute the other, but it can simply complement the other? I think that's the gist of the question.
Oh, okay. Yes. I believe I stated that we are in support of gas supply as well as the introduction of gas as part of energy mix. And years and years, I believe Karpowership have provided solutions. So we can complement. It is, I believe, a complementary energy or renewable energy solution. And for a number of years, if you can even do the research, many at times we've been using gas, but we were not knowledgeable about the ocean production of gas, which is almost cleaner than the one that we produce inland. So it is part and parcel of saying, therefore, how can we learn from such an entity in terms of producing renewable energy using gas?
All right. Thank you very much for your time today, as well as your submissions. We will consider them. All right. Thank you, sis. And ladies and gentlemen, this was the last presenter. I would like to call upon the applicant only for 5 minutes for the applicant to provide final remarks on its application. And it may also touch on one or two things that were mentioned just in response and providing clarification only. That will be for 5 minutes in response, and also just the final remarks to emphasize on its application. The applicant. Do we still have the or then the applicant will not utilize that opportunity. If not, Walter, can you also confirm that we do not have any company called Green Connect? What we had is the Green Connection NPC. Please confirm.
I can confirm that they are not on the platform, Chair. Thank you.
All right. Thank you very much. I do not know the hand that has been raised here, and I will depend on you as the person assisting us today, Mr. Mamunda. We're not taking any other hands except just to get confirmation that the applicant will not utilize its slot of providing concluding remarks as we normally do.
I can't see who is raising hand. I thought maybe perhaps it was the applicant, but I'm not seeing the hand.
Can we have the applicant? Can we confirm if we still have Mr. Katma here as the applicant for the concluding remarks? We only providing 5 minutes. If they want to not making any concluding remarks, please inform us so that we can then adjourn the hearing.
Apologies, I had a technical problem. Apologies.
Okay, we're providing you 5 minutes, and that 5 minutes is merely for your concluding remarks as the applicant, as we finalize the hearings on these applications. And also in your concluding remarks, if you would like to touch on 1 or 2 issues where you would like to respond by way of providing clarification.
Thank you very much. And thank you for NERSA for hosting this public participation hearing. I mean, I think it's a very important process in the granting of licenses, and we value the inputs today. Apparently, some of the issues are quite technical, which we would definitely get back in written some of our responses. But especially for the solution itself, its flexibility and third-party access, those are quite important points for us, which we would like to clarify as much as possible. As I told you, there were certain remarks where there were questions about our engagement with Shell as the LNG supplier and how it affects the overall RMIPP program and our license applications. First of all, our license applications are for each project, and the RFP requires to have your gas licenses in order to reach financial close. So that's what we have been doing by these applications. And our engagement with Shell, the discussions about third-party access exclusivity are purely commercial discussions, which with the letter that we submitted yesterday, we are open to explore any potential for sharing the infrastructure. And again, we would like to point out that these projects, the RMIPP projects, the 3 projects that we have, would be the first test case for LNG infrastructure and should be considered as temporary. We know that other governmental institutions have their permanent long-term plans, which we are happy to change when the time comes. So we believe our projects are the best transitional approach for South Africa to a sustainable economy. Gas to power, as some other stakeholders have said, is a recognized preferred alternative, which has more environmental benefits, what is currently being deployed. And as Karpowership South Africa, we are working day and night to reach financial close. 49% black-owned company with a stated mandate to support socio-economic development and sector transformation. So this is not only a requirement of the tender that all the preferred bidders would have only be selected if they made these transformation and development terms, but really, sincerely, we are doing our best to deliver these projects on time. There are certain permits that we are working, as I try to address during the presentation, which we don't see any big obstacles in front of them. This is more a time issue for the overall program, not only for our project. Once again, we thank you for the opportunity to present today, and we reiterate our continued commitment to our projects in South Africa.
Thank you very much, and we're looking forward to the additional information or responses in the next 7 days. We thank you for your time. Ladies and gentlemen, we have come to the end of today's public hearing on the 5 applications that were lodged by the Karpowership for NERSA to consider and make a final decision in terms of Section 16 of and read with Section 18 and Section 19 of the Gas Act. The energy regulator will be moving towards making a final decision on this matter, as I already indicated that any further delay will not put us on a compliance path with the law, because our Gas Act stipulates statutory timelines within which any application must be processed. So either way, the decision must be taken. So I would like to emphasize that a decision needs to be taken, whichever decision that the energy regulator will take, and that decision will be informed by all of the information that is at the disposal of the energy regulator, including the additional submissions that must be made to the energy regulator from these public hearings in terms of the responses that were expected from the participants today, of which some of those responses the participants undertook to make additional written responses to the energy regulator before we take the decision. So we will take that into consideration. We will also take into consideration all the oral and verbal representations that we've had in the past 2 hearings that we've had on this matter, and the meetings where the energy regulator will be deliberating on the proposed decision that will be tabled to the energy regulator by the NERSA staff. Those meetings are open to the public, for the public to follow all of the considerations and the arguments that are put forward by the members of the regulator before a final decision is taken. So the meetings are open to the public, and the matter will be considered in the subcommittee of the energy regulator, and the final decision will then be taken by the board itself, the body of 9 of the energy regulator members, and that will be the final decision that can never be changed, only reviewable by the court of law, and members and the dates of those meetings will be published through our Facebook and the Twitter cards, as well as LinkedIn cards of the energy regulator, and in the NERSA website for any parties that are interested in following the proceedings and the discussions that will take place at those 2 meetings of the energy regulator when such decision will be taken. I would like to thank all of you for not interrupting the proceedings and for complying with the rules that were read out to you, and for taking your time to observe these proceedings, and for the presenters to come forward and assist the energy regulator with information that may have a bearing on the decision that the energy regulator needs to take. And I also forgot to mention that we also have a YouTube cards, so you may also follow us there, and in terms of the information that we may post on those social media cards for the members of the public to access the services of the energy regulator and processes that we embark on. At this point in time, I would like to thank you to all of the stakeholders. Thank you to the members of the energy regulator that assisted in asking questions for clarification and to satisfy themselves when they get additional information before they take the decision. And to also thank the NERSA team and the team from the gas division that prepared all of the documents that are before us today. And the RSU for organizing these hearings to go so smooth the way that they did today. And I will wish you a good weekend. The hearing is now adjourned. Thank you very much, members. We can log onto a different platform. If Gerald, you are able to take us to the earlier platform whilst we are holding here, just transfer us to that platform for the deliberation.